Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, located in between Fort Worth and Dallas. Today's short video is going to talk about the common ways that employers discriminate against disabled employees and applicants in employment. We'll talk a little bit about the laws that apply that prohibit disability discrimination in employment. We'll talk about who those laws apply to. Then we'll talk about the common ways that employers discriminate against disabled individuals. And then we'll talk briefly about some of the remedies that are available to you if you are a victim of disability discrimination. Here in Texas, disability discrimination in employment is unlawful under both federal and state law. At the federal level, the Americans with Disabilities Act and then the Americans with Disabilities Act Amendments Act in 2008 are generally the laws that people think about when it comes to disability discrimination because it's the most well-known, of course. It's also the most aggressive as far as providing protections for disabled employees. And while the ADA might be the most well-known and aggressive of laws, it's not the first federal law that prohibits disability discrimination. The first law is the Rehabilitation Act, and the Rehabilitation Act is actually still in force and provides the ability to file claims against employers on the basis of disability discrimination. The ADA is actually based upon the Rehabilitation Act, and in many ways supersedes it, but it is out there. It does prohibit disability discrimination, and it's another option if you are facing disability discrimination to bring claims against an employer. Under state law, the Texas Labor Code has very similar provisions to the ADA. Actually, more specifically, it tracks the Rehabilitation Act in many ways. It also prohibits unlawful forms of disability discrimination. It does have many of the same protections that federal law provides, whether it's through the Rehabilitation Act or the ADA. And that's generally the state law that's going to apply. But you can also sometimes look at city-level laws that prohibit disability discrimination that may provide some sort of protection above and beyond the basics that the Texas Labor Code provides. For the most part, we can apply the federal law, the state law, and any local laws that apply in much the same way because they provide as a whole very analogous protections. So we'll just kind of talk about this from one general standpoint as far as what the law prohibits in disability discrimination. These laws prohibit discrimination directly against people who have disabilities, and at very least, the federal law prohibits discrimination against employees or applicants who are closely related to people who have disabilities when that relationship forms the basis for whatever discriminatory act the employer has taken. There's some question whether state law actually prohibits that what we call associational discrimination. Texas courts have never said one way or another, and the Texas Labor Code does not specifically say one way or the other. So maybe there's some difference there, but by and large, there's no question that federal law prohibits that kind of discrimination, even against somebody who is not themselves disabled. And just to give an example of how that works, say you're a parent who has a child with a disability, and maybe your child has a disability, but there's nothing special you have to do to provide care, or at least nothing that would interfere with your job responsibilities. But the employer thinks, well, if your kid has this disability, you're probably going to want time off for work all the time. And so we can't have that. We need workers to show up. So I'm just not going to give you the job, or if I've given you the job, I'm going to fire you. and we'll go find somebody else who doesn't have this problem. In that case, the parent doesn't have a disability, but the parent is being discriminated against because they're related to somebody who has a disability. The reason why we prohibit that kind of discrimination as well is because it's indirectly an attack on people who are disabled, and it is directly an attack on caregivers to people who are disabled. And sometimes people who have disabilities need those caregivers to be available, and those caregivers need to be able to provide care, and one way that they often provide care is by providing financial support, or indirectly providing financial support by providing housing or food or transportation. And so if you can discriminate against the caregiver but not directly discriminate against the disabled person, it is the disabled person who's suffering the effects of that act. Eventually, the caregiver might find a job if the employer doesn't know about the disability, but it's really the disabled individuals who suffer from that kind of discrimination, even though it's indirectly affecting them. So now we know the laws that apply, who they apply to. Let's talk about some common ways employers discriminate against disabled individuals. The first way, most obviously, is employers will fail to hire or refuse to hire somebody who is disabled, or they find out you're related to a disabled person, just keep you from ever getting your foot in the door to the employment relationship, so that the employer doesn't have to deal with any of the issues that might arise, or that they believe might arise. And along with that, maybe you have been hired in and now you're trying to get a promotion. It's also a form of disability discrimination to refuse to promote an employee, or to make a decision not to promote an employee on the basis of that disability, or even a perceived disability. It's worth pointing out that in addition to people who actually have disabilities and people who are related to people who have disabilities, that the laws also cover people who don't actually have a disability, but the employer, for whatever reason, has perceived them of having a disability and or treats them like they have a disability, or if they have a history of having an actual disability but no longer have the disability because it's been treated or cured. So now that we've done a better job of shaping who is covered by these laws, let's go back and point out that that failure to hire an applicant who is disabled, associated with somebody who has a disability, is perceived to have a disability, or has a history of a disability, that's going to be a form of disability discrimination. Refusing to promote them or declining to promote them on the basis of that disability is also a form of disability discrimination. The most aggressive form of disability discrimination, like any kind of discrimination, is terminating the person on the basis of that disability. And maybe the employer doesn't go as far as terminating the employee. The employer might just demote the employee by sending them vertically down the chain to a lower position, or transferring them into another department where the job that they have has less pay or less benefits or fewer job responsibilities, in a way that is actually a demotion, even though it doesn't directly appear that way up front. Any kind of demotion, any kind of job change that reduces compensation or job opportunities is a prohibited form of disability discrimination. Similarly, an employer may not terminate, may not demote, may not transfer you to a less prestigious position. The employer might keep you in the same position, but affect your compensation, perhaps by cutting your pay or giving you a lower bonus or a lower raise, or some other kind of compensation that's paid out because you're disabled, or initially hires you in at a lower pay rate, anything that creates a form of pay inequality between you and non-disabled employees that's set out on the basis of that disability is again a form of disability discrimination. Additionally, like in other forms of unlawful discrimination, harassment is a way that an employer can discriminate against a disabled employee. There's very specific tests as far as what meets the legal definition of harassment, but for now, let's just talk about it as a general concept that an employer can harass an employee on the basis of a disability, either directly through the supervisor harassing the employee, or because the employer allows other people in a non-managerial position to harass the employee. These might be coworkers, they may be people in other departments, they could be customers to the business, they could be outside business partners or vendors that work with the company. Anytime an employee is being harassed on the basis of a disability, the employer has an obligation to step in and stop it. If they're not, or if the employer is perpetrating that harassment through management, that is a form of disability discrimination, even if it's not attached to any kind of pay or job change. And last, there's one form of disability discrimination that is very specific to the disability issue that doesn't exist in other forms of unlawful discrimination, and that's a failure to provide a reasonable accommodation. Under federal and state law, employers have a duty to reasonably accommodate, when requested, a disability by an employee or applicant. There are, like so many other things in employment law, very specific requirements and very specific rules set out about what a reasonable accommodation is when one has been requested, what an employer must do, and what an employer must provide as far as a reasonable accommodation. And that will be another video itself. So let's just again talk about a very general sense of what this means. An employer is required, when an employee or applicant asks for it, to provide a reasonable accommodation that allows an employee to perform the essential functions of their job, or to have meaningful access to the job site, or just to enjoy the same benefits of employment that non-disabled employees have access to, such as being able to use a break room or a coffee machine, for example. So these can range from, something as small as access to the break room or the coffee machine or the microwaves or whatever, all the way up to actual performance of your job, or the ability just to be able to get in the building and get to your desk and do your job. The employer has a duty to provide a reasonable accommodation, and if an employer fails to provide a reasonable accommodation when one is available and has been requested, or the employer fails to take the steps required by the law to investigate the need for the reasonable accommodation and to determine whether one is available, either of those acts are an unlawful form of disability discrimination, even if the employer keeps the disabled person in their job, doesn't cut their pay, doesn't harass them, doesn't transfer them into a different position. The failure to provide the reasonable accommodation is enough by itself to form a claim for disability discrimination. If you have suffered one of these forms of disability discrimination, you do have remedies under both federal and state law to protect your rights, protect your job, and protect your pay. It's important to point out that your remedies are tied against a very specific process that requires you to file an administrative complaint with either the Equal Employment Opportunity Commission or the Texas Workforce Commission within a very limited time frame. If this complaint is not filed in time, there's nothing further you can do to pursue these claims under the laws we've talked about today. So it's important that those are filed, and filed with the right language in them within the right time frame in order to preserve your possible claims. If you do have claims and you've followed the right process, you do have remedies available to you. If you've lost out on job opportunities or had your pay cut, or you've lost a job because of disability discrimination, you're entitled to recover back pay, front pay, any kind of unpaid wage that you've lost as a result of the employer's action. You can also recover certain types of compensatory damages, like punitive damages, losses outside of your actual wages that have occurred as a result of whatever the employer's act was, up to a certain limit. You can also recover attorney fees and interest and cost and some of these other smaller issues. The ability to recover attorney fees makes it so that employment attorneys like myself can help people out on some sort of contingency basis where we're not asking people to shell out what may be ultimately an enormous sum of money to take one of these cases to trial. Instead, we can sort of share that burden together and then share in the payout at the end to make sure that everybody's being paid for their work, much in the same way that you want to. There are some other options that are available that goes beyond just monetary relief. In limited cases, you can pursue reinstatement into a job that you either lost or were not given that you should have received. This is a fairly rare relief that's provided by the courts, and often that's simply because at some point the employer put somebody in whatever position you had or the position you sought that had no direct involvement in that employment decision, and judges rarely like to punish some innocent third party that just wanted a job or a promotion in order to stick you into that position, even if you were entitled to it and capable of performing it. Often the remedies that we're going to pursue are going to be monetary and let you go out and try to find work with an employer who won't discriminate against you and will give you a fair shot and treat you reasonably. And that's really a better result for most people anyway. But in some circumstances, reinstatement might be the right option. And if it's caught early enough, sometimes we can actually reinstate people, and the employer will take steps to resolve whatever the problem was and maybe separate you from whoever the people were that caused the discrimination in the first place. But not all employers are that reasonable or that strongly convicted to make those kind of employment decisions on your behalf. So you may have to settle one way or another for whatever monetary relief is available. But above all else, it's really important that if you think you have a claim for disability discrimination, that you talk to an employment attorney quickly to make sure that the attorney can talk to you, learn about the situation, assess your possible claims, and get that administrative complaint process started so that your rights can be protected under law. So that's pretty much it today. Just wanted to talk somewhat briefly, I guess as briefly as this gets, about the common forms of disability discrimination and the laws that apply. Again, if you think you have a claim, talk to an employment attorney in your area, wherever you might be, and do so as quickly as you can to make sure that you're not sleeping on your rights and missing that deadline to get the administrative complaint filed. So that's, I think that's a good stopping point. Thank you for listening or watching or whatever to this video. I hope it was informative. If you're looking for more information about disability discrimination, there's links below that link to both more information specifically about disability discrimination on my website and to my blog where I discuss other disability discrimination issues as well as other employment law issues, family law issues, and some personal injury issues. So again, thanks for listening. See you next time.